This is as it should be. My cousin, Professor Dr. Michael Hughes, sent me the speech of 1852. Now, mind you, my cousin and I have both debated often uh, the facts regarding where we are as a nation. And often my cousin prefers to license himself with the grandeur of reference to the 1852 writings of Frederick Douglass. But I want you to understand between 1852 and 1960, Frederick Douglass is maturing, growing in wisdom and in stature with God and with man. And in so doing, following many of the abolitionists of the day, the abolitionists are beginning to question his ferocity. Not that he isn't necessarily the most enamored orator of his day, but there is a certain sense of misinterpretation of substance. It has to do with the Constitution. And if he understood the Constitution, then he would also understand patriotism. And if he understood patriotism, he also would then understand republicanism. Frederick Douglass, to the dislike of Professor Dr. Michael Hughes, said, "I am a Republican, a black, dyed in the wool Republican, and I never intend to belong to any other party than the party of freedom and progress." You know, the unfortunate thing is that many a Republican has surrendered the ideas of freedom and progress to the socialistic utopia presented by the left, the Marxists, the socialists, the communists. They defile what Lincoln and what Douglass meant in terms of, by any means necessary, we ascertain freedom and liberty for all. You see, our founding fathers, Thomas Jefferson and George Mason, understood that we were a nation who was impeded, enforced with the industry of slavery. And then there were those here who economically saw its boon, not just in the South. I want you to know Jim Crow extended from Alaska to Florida, from Maine to California, IA. Racism abounded throughout the land. But that did not stop a Booker T. Washington from telling black Americans to drop their bucket where they are and make whatever contribution to society they could make. You see, he was standing on the shoulders of Frederick Douglass, who virtually told him the same thing. But where did Frederick Douglass get the idea of being a dyed-in-the-wool Republican when in 1852 he's blaming America for being the worst? And I want you to understand his fixation on us going to South America was more along the lines of pronouncing the disdain for slavery. When you think of the 4 million slaves that were brought to the United States of America over a 200-year period, I want you to know that 20 million African slaves were taken to South America. Think about that, my friends. But I digress. I want you to hear the words of a man who has finally read the Constitution for himself, and these are his writings as well as his orations. Frederick Douglass, the Constitution of the United States. Is it pro-slavery or anti-slavery? You see, Danny Glover, it's easy to read the cantankerous protestations of a young man with great glib, but it's more enlightening to read how a man grows. And in this particular segment, I want you to grow with me. Frederick Douglass writes, and he gives a speech before the Scottish Anti-Slavery Society in Glasgow, Scotland on March 26, 1860. 1860, we are just a few years short of the war between brothers, fathers, sons, mothers, the Civil War in the United States. Frederick Douglass outlines his views on the American Constitution overseas. He does so. You won't, I promise you will not hear Danny Glover or Professor Michael Hughes or any of the leftists speak of this, for they wish you to be ignorant, and they certainly do not want you to speak with a profession of strength and vigor that the Frederick Douglass of 1852 is not the same Frederick Douglass of 1860. I proceed to the discussion, and first a word about the question. Much will be gained at the outset if we fully and clearly understand the real question under discussion. Indeed, nothing is or can be understood. These are often confounded and treated as the same for no better reason than that they resemble each other, even while they are in their nature and character totally distinct and even directly opposed to each other. This jumbling up things is a sort of dust throwing which is often indulged in by small men who argue for victory rather than for truth. Thus, for instance, the American government and the American Constitution are spoken of in a manner which would naturally lead the hearer to believe that one is identical with the other, when the truth is they are distinct in character, as is a ship and a compass. The one may point right and the other steer wrong. Chart is one thing, the course of the vessel is another. The Constitution may be right, the government is wrong. If the government has been governed by mean, sordid, and wicked passions, it does not follow that the Constitution is mean, sordid, and wicked. I'm putting this paragraph in our chat room for those who are following along at home with us on TECN TV, the Exceptional Conservative Show. No, Frederick Douglass didn't say all that, but I just want to put that in there so that you can refer back to it. I digress. What then is the question? I will state it. But first, let me state what is not the question. It is not whether slavery existed in the United States at the time of the adoption of the Constitution. It is not whether slaveholders took part in the framing of the Constitution. It is not whether those slaveholders in their hearts intended to secure certain advantages in that instrument for slavery. It is not whether the American government has been wielded during 72 years in favor of the propagation and permanence of slavery. It is not whether a pro-slavery interpretation has been put upon the Constitution by the American courts. All these points may be true or they may be false. They may be accepted or they may be rejected without in any wise affecting the real question in debate. The real and exact question between myself and the class of persons represented by the speech at the City Hall may be fairly stated thus. First, does the United States Constitution guarantee to any class or description of people in that country the right to enslave or hold as property any other class or description of people in that country? Second, is the dissolution of the union between the slave and free states required by fidelity to the slave or by the just demands of conscience. Or, in other words, is the refusal to exercise the elective franchise and to hold office in America the surest, wisest, and best way to abolish slavery in America? To these questions, the Garrisonians say yes. They hold the Constitution to be a slave-holding instrument and will not cast a vote or hold office, and denounce all who vote or hold office, no matter how faithful such persons labor to promote the abolition of. I, on the other hand, deny that the Constitution guarantees the right to hold property in man, and believe that the way to abolish slavery in America is to vote such men into power, as well use their powers for the abolition of slavery. This is the issue plainly stated, and ye shall judge between us. Before we examine into the deposition, tendency, and character of the Constitution, I think we had better ascertain what the Constitution itself is. Before looking for what it means, let us see what it is. Here too, there is much dust to be cleared away. What then is the Constitution? I will tell you. It is not even like the British Constitution, which is made up of enactments of Parliament, decisions of courts, and the established usage of the government. The American Constitution is a written instrument, full and complete in itself. No court in America, no Congress, no president can add a single word thereto or take a single word thereto. It is a great national enactment done by the people and can only be altered, amended, or added to by the people. I am careful to make the statement here. In America, it would not be necessary. It would not be necessary here if any assailant had shown the same desire to be set before you the simple truth, which he manifested to make out a good case for himself and friends. Again, it should be borne in mind that the mere text, and only the text, and not any commentaries or creeds written in or by those who wished to give the text a meaning apart from its plain reading, was adopted as the Constitution of the United States. I digress here to tell you that Frederick Douglass was a strict constitutionalist by now. Who knew? I digress. It should also be borne in mind that the intentions of those who framed the Constitution, be they good or bad for slavery or against slavery, are so respected so far and so far only as we find those intentions plainly stated in the Constitution. It would be the wildest of absurdities and lead to endless confusion and mischiefs if, instead of looking to the written paper itself for its meaning, it were attempted to make us search it out in the secret motives and dishonest intentions of some of the men who took part in writing it. It was what they said that was adopted by the people, not what they were ashamed or afraid to say and really omitted to say. Bear in mind also that the fact is an important one, that the framers of the Constitution sat with doors closed, and that this was done purposely, that nothing but the result of their labors should be seen, and that result should be judged of by the people, free from any of the bias shown in the debates. It should also be borne in mind that the fact is still more important, that the debates in the convention that framed the Constitution, and by means of which a pro-slavery interpretation is now attempted to be forced upon that instrument were not published till more than a quarter of a century after the presentation and the adoption of the Constitution. These debates were purposely kept out of view in order that the people should adopt not the secret motives or unexpected intentions of anybody, but the simple text of the paper itself. Those debates form no part of the original agreement. I repeat, the paper itself, and only the paper itself, with its own plainly written purposes, is the Constitution. It must stand or fall, flourish or fade, on its own individual or self-declared character and objects. Again, where would be the advantage of a written constitution if instead of seeking its meaning in its words, we had to seek them in the secret intentions of individuals who may have had something to do with writing the paper? I want to stop here for a moment and inject. Are we listening to Antonin Scalia or are we listening to Frederick Douglass? Was Antonin Scalia telling us what Frederick Douglass had already disposed to us and to the Colin Kaepernick, Al Sharpton, Jesse Jacksons of the world of his day? Don't come in here with this crap. I digress. What will the people of America 100 years hence care about the intentions of the scriveners who wrote the Constitution? These men are already gone from us, and in the course of nature we're expected to go from us. They were for a generation, but the Constitution is for ages. I repeat. They were for a generation, but the Constitution is for ages. Whatever we may owe to them, we certainly owe it to ourselves and to mankind and to God to maintain the truth of our own language and to allow no villainy, not even the villainy of holding men as slaves, which Wesley says is the sum of all villainies, to shelter itself under a fair-seeming and virtuous language. We owe it to ourselves to compel the devil to wear his own garments and to make wicked laws speak out their wicked intentions. Common sense and common justice and sound rules of interpretation all drive us to the words of the law for the meaning made in the speech in the city hall. But good as this argument is, it is not conclusive. Wise man has said that few people have been found better than their laws, but many have been found worse. To this last rule, America is no exception. Her laws are one thing, her practice is another thing. We read that the Jews made void the law by their tradition, that Moses permitted men to put away their wives because of the hardness of their hearts, but that this was not so at the beginning. While good laws will always be found where good practice prevails, the reverse does not always hold true. Far from it. The very opposite is often the case. What then? Shall we condemn the righteous law because wicked men twist it to the support of the wickedness? Is that the way to deal with good and evil? Shall we blot out all distinction between them and hand over to slavery all that slavery may claim on the score of a long practice? Such is the course commanded to us in the City Hall speech. After all, the fact that men go out of the Constitution to prove it pro-slavery whether that going out is to the practice of the government or to the secret intentions of the writers of the paper. The fact that they do go out is very significant. It is a powerful argument on my side. It is an admission that the thing for which they are looking is not to be found where only it ought to be found, and that is in the Constitution itself. If it is not there, it is nothing to the purpose, be it whosoever else it may be. But I shall have no more to say on this point hereafter. The very eloquent lecturer at the City Hall doubtless felt some embarrassment from the fact that he had literally to give the Constitution a pro-slavery interpretation, because upon its face, it of itself conveys no such meaning but a very opposite meaning. He thus sums up what he calls the slaveholding provisions of the Constitution. I quote his own words: Article 1, Section 9 provides for the continuance of the African slave trade for the 20 years after the adoption of the Constitution. Article 4, Section 9 provides for the recovery from the other states of fugitive slaves. Article 1, Section 2 gives the slave states a representation of the 3/5 of all the slave population. And Article 1, Section 8 requires the president to use the military, naval, ordnance, and militia resources of the entire country for the suppression of slave insurrection, in the same manner as he would employ them to repel invasion. Now, any man reading this statement or hearing it made with such a show of exactness would unquestionably suppose that speaker or writer had given the plain written text of the Constitution itself. I can hardly believe that the intended to make any such impression. It would be a scandalous imputation to say he did. Any yet, what are we to make of it? How can we regard it? How can he be screened from the charge of having perpetuated a deliberate and point-blank misrepresentation? That individual has seen fit to place himself before the public as my opponent, and yet I do not wish to think as badly of him as this trick of his would naturally lead me to think. Why did he not read the Constitution? Why did he not read the Constitution? Why did he read that which was not the Constitution? He pretended to be giving chapter and verse, section and clause, paragraph and provision. The words of the Constitution were before him. Why then did he not give you the plain words of the Constitution? Oh, sir, I fear that the gentleman knows too well why he did not. It so happens that no such words as African slave trade, no such words as slave insurrection are anywhere used in the instrument. These are the words of that orator, and not the words of the Constitution of the United States. Now, you shall see a slight difference between my manner of treating this subject and which my opponent has seen fit, for reasons satisfactory to himself, to pursue. What he withheld, that I will spread before you; what he suppressed, I will bring to light; and what he passed over in silence, I will proclaim. that you may have the whole case before you and not be left to depend upon either his or upon my inferences or testimony. Here then are several provisions of the Constitution to which reference has been made. I read them word for word, just as they stand in the paper called the United States Constitution. Article 1, Section 2, representatives and direct taxes shall be apportioned among the several states which may be included in this union according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term years, and excluding Indians not taxed, 3/5 of all other persons. Article 1, Section 9. The migration or importation of such persons as any of the states now existing shall think fit to admit shall not be prohibited by the Congress prior to the year 1808. But a tax or duty may be imposed on such importation not exceeding $10 for each person. Article 4, Section 2. No person held to service or labor in one state under the laws thereof escaping into another shall in consequence of any law or regulation therein be discharged from service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Article 1, Section 8, to provide for calling for the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Here then are those provisions of the Constitution which the most extravagant defenders of slavery can claim to guarantee a right of property in man. These are the provisions which had been pressed into the service of the human fleshmongers of America. Let us look at them just as they stand one by one. Let us grant for the sake of the argument that the first of these provisions, referring to the basis of representation and taxation, does refer to slaves. We are not compelled to make the omission, for it might fairly apply to aliens, persons living in the country but not naturalized. But given the provisions the very worst construction, what does it amount to? I answer. It is a downright disability laid upon the slaveholding states, one which deprives those states of 2/5 of their natural basis of representation. A black man in a free state is worth just 2/5 more than a black man in a slave state as a basis of political power under the Constitution. Therefore, instead of encouraging slavery, the Constitution encourages its freedom by giving an increase of 2/5 of political power to free over slave states. So much for the 3/5 clause. Gentlemen, taking it at its worst, it still leans to freedom, not slavery. For be it remembered that the Constitution nowhere forbids a colored man to vote. I repeat to you, the Constitution nowhere forbids a colored man to vote. I will also, no, I come to the next, forgive me, that which it is said guaranteed the continuance of the African slave trade for 20 years. I will also take that for just what my opponent alleges it to have been, although the Constitution does not warrant any such conclusion, but to be liberal, Let us suppose it did. And what follows? Why this? That this part of the Constitution, so far as the slave trade is concerned, became a dead letter more than 50 years ago, and now binds no man's conscience for the continuance of any slave trade whatsoever. Mr. Thompson is just 52 years too late in dissolving the Union on account of this clause. He might as well dissolve the British government, because Queen Elizabeth granted to Sir John Hawkins to import Africans into the West Indies 300 years ago. But there is still more to be said about this abolition of the slave trade. Men at that time, both in England and America, looked upon the slave trade as the life of slavery. The abolition of the slave trade was supposed to be the certain death of slavery. Cut off the stream, and the pond will dry up, was the common notion of the time. Wilberforce and Clarkson, clear-sighted as they were, took this view, and the American statesmen, in providing for the abolition of the slave trade, thought they were providing for the abolition of the slavery. This view is quite consistent with the history of the times. All regarded slavery as an expiring and doomed system, destined to speedily disappear from the country. But again, it should be remembered that this very provision, if made to refer to the American slave trade at all, makes the Constitution anti-slavery rather than for slavery. For it says to the slave states, the price you will have to pay for coming into the American Union is that the slave trade, which you would carry on indefinitely out of the Union, shall be put an end to in 20 years if you come into the Union. Secondly, if it does apply, it expired by its own limitation more than 50 years ago. Thirdly, it is anti-slavery because it looked to the abolition of slavery rather than to the perpetuity. Fourthly, it showed that the intentions of the framers of the Constitution were good, not bad. I think this is quite enough for this point. I go to the slave insurrection clause. Though in truth there is no such clause. The one which is called so has nothing whatever to do with slaves or slaveholders any more than your laws for suppression of popular outbreaks has to do with making slaves of you and your children. It is only a law for suppression of riots or insurrections, but I will be generous here as well as elsewhere and grant that it applies to slave insurrections. Let us suppose that an anti-slavery man is president of the United States, and the day that shall see this the case is not distant. This very power suppressing slave insurrections would put an end to slavery. The right to put down insurrection carries with it the right to determine the means by which it shall be put down. If it should turn out that slavery is a source of insurrection, there is no security from insurrection while slavery lasts, why the Constitution would be best obeyed by putting an end to slavery. And an anti-slavery Congress would do the very same thing. Thus, you see, the so-called slave-holding provisions of the American Constitution, which a little while ago looked so formidable, are, after all, no defense or guarantee for slavery whatever. But there is one other provision. This is called the fugitive slave provision. It is called so by those who wish to make it subversive, to make it subserve the interests of slavery in America, and the same by those who wish to uphold the views of a party in this country. It is put thus in the speech at City Hall. I quote, "Let us go back to 1787 and enter Liberty Hall, Philadelphia, where sat in convention the illustrious men who framed the Constitution, with George Washington in the chair. On the 27th of September, Mr. Butler and Mr. Pinckney, two delegates from the state of South Carolina, moved that the Constitution should require that fugitive slaves and servants should be delivered up like criminals, and after a discussion on the subject, the clause as it stands in the Constitution was adopted. After this, in the conventions held in the several states to ratify the Constitution, the same meaning was attached to the words. For example, Mr. Madison, afterwards president, when recommending the Constitution to his constituents, told them that the clause would secure them their property and slaves." I must ask you to look well to this statement. Upon its face, it would seem a full and fair statement of the history of the transaction it professes to describe, and yet I declare unto you, knowing as I do the facts in the case, my utter amazement at the downright untruth conveyed under the fair seeming words now quoted. The man who could make such a statement may have all the craftiness of a lawyer, but who can accord to him the candor of an honest debater? What could more completely destroy all confidence in his statements? Mark you, the orator had not allowed his audience to read the provision of the Constitution to which he referred. He merely characterized it as one to deliver up fugitive slaves and servants like criminals, and tells you that this was done after discussion. But he took good care not to tell you what was the nature of that discussion. He would have spoiled the whole effect of his statement had he told you the whole truth. Now, what are the facts connected with the provision of the Constitution? You shall have them. It seems to take two men to tell the truth. It is quite true that Mr. Butler and Mr. Pinckney introduced a provision expressly with a view to the recapture of fugitive slaves. It is quite true also that there was some discussion on the subject, and just here the truth shall come out. These illustrious kidnappers were told promptly in that discussion that no such idea as property in man should be admitted into the Constitution. The speaker in question might have told you, and he would have told you, but the simple truth, if he had told you that he propositioned of Mr. Butler and Mr. Pinckney, which he leads you to infer was adopted by the convention that from the Constitution, was in fact promptly and indignantly rejected by that convention. He might have told you, had it suited his purpose to do so, that the words employed in the first draft of the Fugitive Slave Clause were such as applied to the condition of slaves, and expressly declared that persons held to servitude should be given up, but that the word servitude was struck from the provision for the very reason that it applied to slaves. He might have told you that the same Mr. Madison declared that the word was struck out because the convention would not consent that the idea of property in men should be admitted into the Constitution. The fact that Mr. Madison can be cited on Both sides of this question is another evidence of the folly and absurdity of making the secret intentions of the framers the criterion by which the Constitution is to be construed. But it may be asked, if this clause does not apply to slaves, to whom does it apply? I answer that when adopted, it applies to a very large class of persons, namely redemptioners, persons who had come to America from Holland, from Ireland, and other quarters of the globe, like the coolies to the West Indies, and had for a consideration duly paid become bound to serve and labor for the parties to whom their service and labor was due. It applies to indentured apprentices and others who have become bound for consideration under contract duly made to serve and labor. To such persons, this provision applies, and only to such persons. The plain reading of this provision shows that it applies and that it can only properly and legally apply to persons bound to service. Its object plainly to secure the fulfillment of contracts for service and labor. It applies to indentured apprentices and any other persons from whom service and labor may be due. The legal condition of the slave puts him beyond the operation of this provision. He cannot even make a contract. He is not described in it. He is a simple article of property. He does not owe and cannot owe service. He cannot even make a contract. It is impossible for him to do so. He can no more make such a contract than a horse or an ox can make one. This provision, then, only respects persons who owe service, and they can only owe service who can receive an equivalent and make a bargain. The slave cannot do that, and is therefore exempted from the operation of this fugitive provision. In all matters where laws are taught to be made the means of oppression, cruelty, and wickedness, I am for strict construction. I will concede nothing. It must be shown that it is so nominated in the bond. The pound of flesh, but not one drop of blood. The very nature of law is opposed to all such wickedness and makes it difficult to accomplish such objects under the forms of law. Law is not merely an arbitrary enactment with regard to justice, reason, or humanity. Blackstone defines it to be a rule prescribed by the supreme power of the state, commanding what is right and forbidding what is wrong. I digress for a moment here. Frederick Douglass knew about Blackstone? You wouldn't know that by Colin Kaepernick, now would you? I digress. The speaker at the city hall laid down some rules of legal interpretation. These rules send us to the history of the law for its meaning. I have no objection to such a course in ordinary cases of doubt, but where human liberty and justice are at stake, the case falls under an entirely different class of rules. There must be something more than history, something more than tradition. The Supreme Court of the United States lays down this rule, and it meets the case exactly. Where rights are infringed, where the fundamental principles of the law are overthrown, where the general system of the law is departed from, the legislative intention must be expressed with irresistible clearness. The same court says that the language of the law must be construed strictly in favor of justice and liberty. Again, there is another rule of law. It is where a law is susceptible of two meanings, the one making it accomplish an innocent purpose and the other making it accomplish a wicked purpose, we must in all cases adopt that which makes it accomplish an innocent purpose. Again, the details of a law are to be interpreted in the light of the declared object sought by the law. I set these rules down against those employed at the city hall. To me, they seem just and rational. I only ask you to look at the American Constitution in the light of them, and you will see with me that no man is guaranteed a right of property in man under the provisions of that instrument. If there are two ideas more distinct in their character and essence than another, those ideas are persons and property, men and things. Now, when it is proposed to transform persons into property and men into beasts of burden, I demand that the law that completes such a purpose shall be expressed with irresistible clearness. The thing must not be left to inference, but must be done in plain English. I know how this view of the subject is treated by the class represented at the City Hall. They are in the habit of treating the Negro as an exception to general rules. When their own liberty is in question, they will avail themselves of all rules of law which protect and defend their freedom. But when the black man's rights are in question, they concede everything, admit everything for slavery, and put liberty to the proof. They reserve the common law usage and presume the Negro a slave unless he can prove himself free. For perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States: defense, welfare, tranquility, justice, and liberty. These are all good objects, and slavery, so far from being among them, is a foe of them all. But it has been said that Negroes are not included within the benefits sought under this declaration. This is said by the slaveholders in America. It is said by the City Hall orator. But it is not said by the Constitution itself. Its language is we the people, not we the white people, not even we the citizens, not we the privileged class, not we the high, not we the low, but we the people, not we the horses, sheep, and swine and wheelbarrows, but we the people, but we the human inhabitants. And if Negroes are people, they are included in the benefits for which the Constitution of America was ordained and established. But how dare any man who pretends to be a friend to the Negro thus gratuitously concede away that the Negro has a right to claim under the Constitution? Why should such friends invent new arguments to increase the hopelessness of his bondage? This I undertake to say as a conclusion of the whole matter, that the constitutionality of slavery can be made out only by disregarding the plain and common sense reading of the Constitution itself, by discrediting and casting away as worthless the most beneficent rule of legal interpretation, by ruling the Negro outside of these beneficent rules, by claiming that the Constitution does not mean what it says and that it says what it does not mean, by disregarding the written Constitution and interpreting it in the light of a secret understanding. It is in this mean, contemptible, and underhand method that the American Constitution is pressed into the service of slavery. They go everywhere else for proof that the Constitution declares that no person shall be deprived of life, liberty, or property without due process of law. It secures to every man the right of trial by jury, the privilege of the writ of habeas corpus, the great writ that put an end to slavery and slave hunting in England, and it secures to every state a republican form of government. Any one of these provisions in the hands of abolition statesmen, backed up by a right moral sentiment, would put an end to slavery in America. The Constitution, my friends, the Constitution forbids the passing of a bill of attainder. That is a law entailing upon the child the disabilities and hardships imposed upon the parent. Every slave law in America might be repealed on this very ground. The slave is made a slave because his mother is a slave. But to all this, it is said that the practice of the American people is against my view. I admit it. They have given the Constitution a slaveholding interpretation. I admit it. They have committed innumerable wrongs against the Negro in the name of the Constitution. Yes, I admit it all. And I go with him who goes farthest in denouncing these wrongs. But it does not follow the Constitution is in favor of these wrongs because the slaveholders have given it that interpretation. To be consistent in his logic, the City Hall Speaker must follow the example of some of his brothers in America. He must not only fling away the Constitution, but the Bible. The Bible must follow the Constitution, for that too has been interpreted for slavery by American divines. Nay, more, he must not stop with the Constitution of America, but make war with the British Constitution, for if I mistake not, the gentleman is opposed to the union of church and state. In America, he called himself a Republican. Yet, he does not go for breaking down the British Constitution, although ye have a queen on the throne and bishops in the House of Lords. My argument against the dissolution of the American Union is this. It would place the slave system more exclusively under the control of the slaveholding states and withdraw it from the power in the northern states, which is opposed to slavery. Slavery is essentially barbarous in its character. It, above all things else, dreads the presence of an advanced civilization. It flourishes best wherein it meets no reproving frowns and hears no condemning voices. While in the Union, it will meet with both. It hopes of life in the last resort is to get out of the Union. I am therefore for drawing a bond of the Union more completely under the power of the free states. What they most dread, that I most desire. I have much confidence in the instincts of the slaveholders. They see that the Constitution will afford slavery no protection when it shall cease to be administered by slaveholders. They see, moreover, that if there is once a will in the people of America to abolish slavery, this is no word, no syllable in the Constitution to forbid that result. They see that the Constitution has not saved slavery in Rhode Island, in Connecticut, in New York, or Pennsylvania. That the free states have only added 3 to their original number. There were 12 slave states at the beginning of the government. There are 15 now. The dissolution of the Union would not give the North a single advantage over slavery, but would take it take from it many. Within the Union, we have a firm basis of opposition to slavery. It is opposed to all the great sub-objects of the Constitution. The dissolution of the Union is not only an unwise but a cowardly measure. 15 millions running away from 350,000 slaveholders. Mr. Garrison and his friends tell us that while in the Union we are responsible for slavery, he and they sing out, "No union with slaveholders," and refuse to vote. I admit our responsibility for slavery while in the Union, but I deny that going out of the Union would free us from the responsibility. There now clearly is no freedom from responsibility for slavery to any American citizen short to the abolition of slavery. The American people have gone quite too far in this slaveholding business now to sum up their whole business of slavery by singing out the cant phrase, "No union with slaveholders." To desert the family hearth may place the recreant husband out of the presence of his starving children, but this does not free him from responsibility. If a man were on board of a pirate ship and in company with others had robbed and plundered, his whole duty would not be performed simply by taking the longboat and singing out, "No union with pirates." His duty would be to restore the stolen property. The American people in the northern states have helped to enslave the black people. Their duty will not have been done until they give them back their plundered rights. Reference was made at the city hall to my having once held other opinions, and very different opinions to those I have now expressed. An old speech of mine delivered 14 years ago was read to show I know not what. Perhaps it was to show that I am not infallible. If so, I have to say in deference that I never pretended to be. Although I cannot accuse myself of being remarkably unstable, I do not pretend that I have never altered my opinion, both in respect to men and things. Indeed, I have been very much modified both in feeling and opinion within the last 14 years. When I escaped from slavery and was introduced to the Garrisonians, I adopted very many of their opinions and defended them just as long as I deemed them true. I was young, had read but little, and naturally took some things on trust. Subsequent experience and reading have led me to examine for myself. This had brought me to other conclusions. When I was a child, I thought and spoke as a child. But the question is not as to what were my opinions 14 years ago, but what they are now. If I am right now, it really does not matter what I was 14 years ago. My position now is one of reform, not of revolution. I would act for the abolition of slavery through the government, not over its ruins. If slaveholders had ruled the American government for the last 50 years, let the anti-slavery men rule the nation for the next 50 years. The South has made the Constitution bend to the purposes of slavery. Let the North now make that instrument bend to the cause of freedom and justice. If 350,000 slaveholders have, by devoting their energies to that single end, been able to make slavery the vital and animating spirit of the American Confederacy for the last 72 years, now let the free men of the North, who have the power in their hands, who can make the American government just what they think fit, resolved to blot out forever the foul, haggard crime, which is the blight and mildew, the curse and the disgrace of the whole United States. Those are the words of Frederick Douglass in his speech, The Constitution of the United States. Is it pro-slavery or anti-slavery? Done in March 1860. As you can see, Danny Glover, he was once a child, but he did not get up on stage and read the words of a child. He grew to become a man. He acted as a man, and he wrote and spoke as one. You speak of his youth to support your bitter respite of the United States. I speak of his wisdom to show you that we are a more perfect union. Danny Glover, you're 40 years my senior, and yet I must say to you, grow up. I want to thank you all so much for staying tuned tonight for this very special presentation. And I look forward to your return tomorrow night for more of the best in urban conservative talk. I want to thank my great sponsors. First and foremost, Frederick Douglass again. I am a Republican, a black, dyed-in-the-wool Republican, and I never intend to belong to any other party than the party of freedom and progress. I want to thank my sponsors, Euro Pacific Bank. Thank you all so much. EuroPacBank.com. I want to thank my sponsor, J. Morrison Academy. Go there. Make sure that you get your financial lives in order. I want to thank my sponsor, Armed Citizens Legal Defense Network Incorporated. Call them today, 360-978-5200, armedcitizensnetwork.org. And oh my God, please, whatever you do, you need to go to belvederedelectables.com. Get your side. I'm telling you, it is to dying for. Really. Get their side dishes and more. Make certain that you do pick up their beloved beans. Oh my God, that is the most delicious thing I've eaten in a long time. Listen, for all of those who are watching at home, I thank you so much for doing so. If you don't remember anything else I said tonight, I hope that you do remember this. God bless America. It is now time for America to bless God. Mary Brockman, smooches to you, Mrs. Biggs. Smooches to you, to everyone else who's been watching. God bless you. I love you dearly. I look forward to you coming back tomorrow night. We'll see you tomorrow.